Hi, Monica Miller here, Legal Director and Senior Counsel for the American Humanist Association. This is Legal Tuesdays, where I answer your questions about separation of church and state. You've asked for us not only on our social media platforms, but also on our new form that you can submit your questions via email if you prefer not to write them in the comments. And we actually got several this week. So I'll start with a question from Teresa Ray Martinez, who says, how is the federal government not supporting an established religion with the following? 1 is God on money, 2 is God in the Pledge of Allegiance, 3 is the phrase act of God when used for natural disaster funding, and 4th is prayer and the Pledge of Allegiance at government meetings. So there's a ton to unpack here. I'll try to do it in the limited time that I have. To start with is a little bit of background that God was, these theistic references were inserted into federal legislation in the 1950s as part of the McCarthy era, anti-communism, anti-atheist. There was a lot of prejudice. I mean, there's still a lot of prejudice, but there was very overt discrimination against atheists at that time, and it made its way all the way through federal legislation, adding God to the currency, to our national motto, and to the Pledge of Allegiance. I've actually worked on this issue very closely with Michael Newdow, the attorney who filed and had his challenge to the Pledge of Allegiance brought all the way up to the Supreme Court. The Supreme Court has not yet ruled on the merits of any of these theistic references with respect to God and the pledge, motto, and currency because the Mike Newdow case ended up getting tossed out on standing, so on a procedural ground. But what happened is, as the Supreme Court does in many cases, especially where standing is at issue, is they end up saying what they would have written if they were to uphold or deny or strike down the challenged action. So in this particular case, you had a lot of language from justices on both sides of the political aisle, basically saying they didn't see a big problem with God being in the pledge. They all had very different rationales. The more prevailing one that you see in Supreme Court decisions in dicta, but also in lower court decisions, and by dicta I mean in passing, so it was never actually the issue before the court to rule on. But basically they say that when God is used in these political contexts, it doesn't mean a religious God or say the Pledge of Allegiance, because that was the case with Mike Newdow. The court basically said, kind of through rote repetition, it's not a theist, it's not a sectarian term, and by basically just saying it over and over again, it kind of loses its religious meaning. Effectively, the court and various other federal judges have concluded that just the word God in certain contexts is not that religious, which to me is a big problem if I was religious, because you're basically now saying that my God is meaningless. And so it kind of begs the question of why religious people really want this mixing between religion and government. So the next question was the phrase act of God when used for natural disaster funding. That particular term you'll see probably more frequently in like insurance policies and waiver forms and that kind of thing. I think it's a hang up from the olden days, the common law days. It was a term that was just used, and that example actually is one where I hear act of God and I almost don't think of it as religious. So almost to some of the Supreme Court members' points, now the 1950s and all of that federal legislation was specifically designed to target and combat atheism and to bring religion back to the families and to mix government and religion. The 1950s actions were different. When the phrase act of God is used, most people understand that just to mean nature, natural disasters, but I think it's a little bit more encompassing of things that are out of your control. I don't love it, but it would certainly not be something I would challenge in court, considering that the challenges in the lower federal courts to the God and the currency, as well as the Supreme Court, all of the dicta, all the statements that the Supreme Court's made, would not give me a lot of confidence bringing any sort of challenge to a document that says act of God. I think, again, it's kind of unfortunate, but I really think the real losers in that situation are those folks who believe in God, because the result is a watered down, almost non-theistic expression that sort of detracts from their religious belief. And lastly, prayer and the Pledge of Allegiance at government meetings. Well, I think we can set aside the Pledge of Allegiance because, like I said, so far challenges have not been successful. We brought 2 challenges to Pledge of Allegiance with respect to under God in state courts and weren't successful, even though we brought those under the state constitutions that specifically said you cannot discriminate on the basis of religion or creed. That it just hasn't been successful. There are certainly other rights that we defend with respect to the pledge, and it doesn't mean that at some future point we wouldn't bring a challenge again to the under God language, but just right now, in the way the courts are shaking up, it's not a viable lawsuit right now. But with respect to prayer at government meetings, it's also a very nuanced answer because it really depends on your jurisdiction and what the kind of prayers are and who's delivering them and what the policy is. The Supreme Court's issued 2 rulings on legislative prayer. One was the Marsh versus Chambers case in the 80s, and then the other one is the Town of Greece case that came out in 2014. Effectively, the courts that have been interpreting the 2014 decision have also been divided. That's why it depends where you are located, because some courts, like the Fourth Circuit, have said that the government officials cannot give the prayers, but if they create sort of an all-comers policy where anyone can deliver a prayer, even an atheist, which was the case in the Town of Greece decision, 2014 decision, but the government themselves cannot be giving the prayers. There's other courts that have said it's fine if the government gives prayers. So it really is a mess right now, and it does depend on a very nuanced set of facts. So if there is a particular government meeting that you are aware of where prayers have been delivered, let us know. We did actually win a case in Maryland post Town of Greece, post that 2014 decision, because the council members themselves were giving the prayers. So that's all I have time for today, but I look forward to talking to you on the next segment of Legal Tuesdays.